Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I want to touch on an issue that is probably the issue that I get telephoned the most about in relation to calls from individuals, and that is the issue of redundancy during maternity leave. So if a post only becomes redundant because somebody is pregnant or on maternity leave, i.e. the employer is deciding to get rid of the post just because the woman happens to be pregnant, then of course that is sex discrimination. And I never fail to be surprised at how many times somebody phones me who maybe works as one of a pool of employees doing something where none of the other people have been put in the pool of selection for redundancy. They seem to have been zoned in on, which obviously smacks as being rather unfair. So enough said on that subject probably. If they are in a pool situation, so there's a number of employees who are potentially at risk of redundancy, but it is the one who happens to be on maternity leave at the moment who is selected for redundancy. If that was the reason why the employer chose that person, then again that would be absolutely sex discriminatory. You'd think not many employers would go down that road, but you'd be surprised how often it comes up. So I'm going to talk about what happens when somebody goes through a selection process fairly and are assessed in some shape or form, usually using some kind of matrix against their colleagues, and they happen to be the one who is selected, or because the job that they previously worked in is disappearing from the structure, they are provisionally selected for redundancy. There's something called Regulation 10 of the 1999 Maternity and Paternity Regulations that gives the pregnant or lady on maternity leave priority rights over her colleagues, so that if somebody's in that position and they happen to be made redundant, then they get these priority rights. So they're not immune from being involved in the consultation or being put at risk or going through the selection process. But if the outcome of that process is that the spotlight falls on them as the potentially redundant one, then the employer has to prioritise them for suitable alternative employment. So they're not immune from the redundancy situation, because if we did that, then that would be unfair and potentially indirectly discriminatory against men who might also be involved in the pool. So back to our scenario with suitable alternative employment. Essentially what that does is mean if there's a vacancy, it's a suitable vacancy for the employee, then they get first dibs in that role. So you might have a situation where you have a job and there may be 2 or 3 people who are at risk of redundancy who are able to put their hat in the ring for that job. If one of those 3 people is on maternity leave, then she automatically gets that job if it's suitable, and we don't have to go through the process of assessing her against those 2 colleagues. She gets first dibs at that job. But what about where there isn't that kind of head-to-head first dibs situation? It may be that it's not clear that the role that we have got available, so there is a vacancy, it may not be suitable. And there's a case called Simpson that dealt with this against Ensley, the insurers. And what's happened in that case is the insurer were closing down branches and moving everything to a much more centralised call centre kind of environment. And employees were able to relocate if they wished, but obviously it would take them to a different part of the country. The employee who was on maternity leave when her post was redundant, so Regulation 10 kicked in, was given the opportunity if she wanted to relocate, etc. But she argued, I should have been slotted in first of all before any terms such as location or, in this particular case, shift pattern were being discussed, because the alternative job that was available had a 7-day-a-week shift pattern, which previously the employee had not wanted to work. The Employment Appeal Tribunal looked at this and they said, no, that's not how it works. It isn't a question of slot in and then worry about everything else. The question of suitability is an objective one for the employer to look at. And that's going to involve looking at all the different factors in the round. So what is the job? What is involved in it? What are the skills and attributes needed to do that job? And who have we got here by way of employee? Would you be able to slot that employee into doing that job? And if the concern is that the two are not matched, then the employer is going to have to be able to justify to a judge why they haven't done that priority slotting in, and why they're saying that job is different or requires different skills or training. And a bit like existing redundancy alternative employment cases, you're probably going to have to show that the gap, if there is one, between the employee and the job that's available is more than just, a little bit of training and coaching and learning new things in the job. It would have to be, a bit of a gulf to say no. But ultimately, an employer can say, well, actually, we have got a vacancy, but it's not suitable alternative employment. And if that's the case, then Regulation 10, if you like, falls away and potentially the employee is redundant, unless, of course, there are other jobs that perhaps become available because another employee resigns or hands in their notice, etc. So it's not a clear-cut thing, and employers are going to have to look at all the issues. If you've got any questions, please do get in touch. It's adenton@refreshinglawltd.co.uk. Thank you very much.